Hello, everybody. My name is Timothy Scott, or TJ Scott, and really I prefer TJ Scott. I'm the owner of the law office of Timothy J. Scott, and I'm an estate planning attorney. And what that means is I help people avoid court and conflict in their families when something happens to them, meaning either incapacity or death. And I'm really happy to have you here today. I know that we're talking about something that is difficult to talk about, but I also believe that knowledge is power. And today, that's what I want to do. I want to empower you. I want to give you the information that you need so that you can have some peace of mind around this topic and know the best way forward to making sure that your family is taken care of if you can't be there with them anymore to take care of them. So today, again, I have some really valuable information I want to share with you and some valuable offers that I'm going to be sharing at the end of the presentation. So please stick around. The best way to learn today is to be here and be present with me. And I really encourage you to turn off any distractions that you might have and give yourself the time that you've already set aside to learning about this topic and to learning about estate planning and spending with me. I encourage you to give yourself this time to really dedicate to learning about this topic. It is complex. There are some kind of confusing things that we're going to go through, and giving your attention, keeping all your attention here is really the best way to internalize this and really learn this information. And I always say your future self is going to thank your past self, present self, for taking the time and dedicating it to being here and learning with me today. Again, I have a ton of great information. I am an open book where you can pick my mind about whatever you want in this area, even outside of this area if you want, although really this is my area of expertise or my area of greatest knowledge, that I am happy to share with you as much information as I have today. And I hope you'll take advantage, and I hope you'll ask your questions. And again, if you stick around until the end, I have some great offers that I want to give you. The first offer is how you can get a free virtual one-on-one meeting with me, where we'll talk about the things that you have and the people that you love and exactly what you can do to protect the people that you love for after you're gone, or if you become incapacitated before you die. Plus, I have a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place for the people that you love after you're gone. But again, you've got to stick around to see those offers at the end. So I have a question for everybody. Do you have an estate plan? And I'm going to go ahead and post this. You should see it come up as a poll. Do you have an estate plan? And an estate plan can mean a lot of different things. Here I have a trust, will, guardianship nomination, healthcare directive, power of attorney, beneficiary designations. All of these things are really part of an estate plan. So when somebody talks to you about having an estate plan in place and they say, well, yeah, I have an estate plan, you know, I filled out a healthcare directive at the hospital. Well, that's really a part of an estate plan. It's really not the entirety of an estate plan. An estate plan really needs all of these parts, and it needs all of these parts working in harmony to really protect the things that you have and protect the people that you love and make sure that they're well cared for. And in the same way, if somebody tells you, well, yes, I have an estate plan, I have a will filled out, no worries, I'm taken care of, that's fine. A will is an essential part of an estate plan, but a will is not an entire estate plan in and of itself. And I'm going to be talking about some other things that go into an estate plan today. I'm going to talk about some concepts that are advanced in that you really want to make sure that you not only have all of the parts of an estate plan, but that you have a good working knowledge to surround those parts and make sure that everything is included. So I see not everybody here has an estate plan in place today, and I understand that. Let me ask though, if you don't have an estate plan in place, does one of these reasons on the screen resonate with you? Maybe you feel like you are just too busy and you've just never had time to sit down and commit to actually doing an estate plan. And I totally get that. As a father of 3 young children and a business owner, I know how busy life can be. But if that's the case, again, I just want to commend you for being here and setting aside this time today. I know how hard that is to set aside time to learn and to educate yourself. And you've really committed to that today, to being with me and exploring this topic and getting yourself some peace of mind. And maybe you feel like you're too young. And the truth is, anyone over the age of 18 should really have an estate plan in place. I recently helped a young family where a young father had passed away. And unfortunately, he had left something of a mess behind for his wife and minor daughters. Um, but that doesn't have to be the case. I've helped young people, especially young families, get estate plans in place. And I've seen the relief on their faces when that burden has been lifted from their shoulders, because they know exactly how their kids are going to be taken care of and exactly how their assets are going to go to the people that they want. They know it's going to be simple for their families, and they know that they are really giving a gift to the people that they love in getting it done. So really, anyone over the age of 18 needs to have some at least basic estate planning documents in place. And so if you have kids who are over the age of 18, but maybe they don't have a home yet, or they don't have something else, there are still some essential documents that you're going to want them to have, including things like a healthcare directive and power of attorney that are really useful in case something does happen and it's needed. And I do see somebody is saying that they're worried that estate planning is too expensive. And I will say, before the advent of word processing, estate planning really was just for the wealthy. There were a lot of requirements to actually getting an estate plan done. They had to be filled out in triplicate. And if you made any kind of mistake, you had to tear the whole thing up and start again. People's time was very expensive then. But today, estate planning is accessible to everybody. It really is for everyone. And in fact, I do have some bonuses, as I've mentioned before, at the end that are going to make it even more affordable to get a great estate plan in place. And I do see somebody is worried about jinxing themselves, and I totally get that. But I want to set your mind at ease. I have done dozens of estate plans, and I have never seen a correlation between somebody getting their estate plan done and having something happen to themselves or in their family. There just isn't a correlation there. And in fact, I always say, my clients tend to live more intentionally and get more enjoyment from their lives, knowing what's going to happen when they're gone. I do see somebody saying, TJ, this summer, a friend in Ohio lost his 56-year-old brother very suddenly. Fortunately, his brother was a very private person who confided in no one, kept financial information private, and left no will. The burden on my friend and his father was unbearable. And yeah, my heart goes out to your friend. That is a really hard situation, and they have a lot of really hard times that they're going to be going through, trying to get everything sorted out for this individual, and making sure that they haven't missed anything, and that everything is going in the way that they believe he would have wanted it to go. But he hasn't set that down anywhere, it sounds like, where it's clear what his intentions were, and certainly not in a legally documented way. And so it's 56 is too young, but you hear it too often, this kind of thing happening. All right, if you have a plan in place, and I believe that some people did say that they do have a plan in place, I want to know, what is it that you want to learn here today? And maybe it is more than one of these things. Also, if you don't have an estate plan in place, but one of these items on this poll resonates with you, I hope that you'll let me know what it is. Or if you have something else that you really want to learn about today, I hope that you'll put a message either in the chat or the Q&A. I can see both of those. When I'm looking over this direction, that's what I'm looking at. But I hope that you'll put that information in there to kind of guide this presentation today, and let me know what it is exactly that people seem to want to know. So maybe what's brought you here today is you want to know if an online do-it-yourself will is okay and is going to take care of the people that you love. Or maybe you created a plan, but it's been a long time. Maybe you had minor children at the time, but now those minor children are no longer minor and they're having their own minor children, something like that. And you want to know, is my plan outdated? Is it still going to work? Is it still going to do what I want it to do? Or maybe you worked with an estate planning attorney who kind of breezed through the information, made a lot of choices for you, and didn't educate you and empower you as you were creating your plan. And now you want to have a better understanding of your plan and exactly what was done for you and what it really means. And I do see that that seems to be a prevalent theme, that people want to understand this concept. They want to understand estate planning, and they want to understand exactly what this looks like and what it means. Again, post in the chat or in the Q&A box if you have a specific question that you have. I do have somebody saying, I have no family, no kids. Who can be my guardian or power of attorney? And that is a really fantastic question. There are places where you can reach out and have somebody serve as an agent or as an attorney, in fact, for you. They're called professional fiduciaries. There are some individuals who will do it. There are also some organizations like First Fiduciary who will take on that role. I haven't worked with First Fiduciary, but I've heard that they will take on that role. Something that's harder is finding somebody to be a healthcare agent or a guardian for you, because people generally don't want to take on the responsibility of making healthcare decisions for you. A guardian can be appointed by a court in something like a guardian ad litem, but also that's generally not a very good situation. It's not something that you want to see happen. And so if you're having that struggle, if you don't have any family that you would trust that responsibility to, I encourage you to reach out to me, and we can brainstorm together, and we can talk about who might be in a good position to take care of those decisions and make sure that you are well taken care of. Oftentimes, we can explore your family and we can explore your friends, and we can find somebody who might be willing to take on that role, especially if they have some kind of financial incentive to take on that role. And I know that's not ideal, but sometimes, we're just working with what we have and trying to figure it out. So again, I hope that you'll reach out to me if that's a concern that you have, and it's something that we can brainstorm on a little bit more. I want to let you know that you are in the right place here today. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, or you're thinking about doing a do-it-yourself will, but you're not sure if it's going to work and if it's going to take care of your family the way that you want it to. And you're in the right place if you're nervous about how much this is going to cost. I completely understand that. Again, as a father of 3 young kids, I'm very sensitive to cost myself. And I will talk about exactly what you can expect to spend on an estate plan a little bit later here in the presentation. The reality is estate planning isn't about us. And this is something that really became clear to my wife and I when we were updating our plan recently. It's not about us, the individuals who are actually doing the estate plan. It's not about enriching our lives or bringing wealth or anything like that to us. But it's really about the people that we love and making sure that they are taken care of when we can't be there to take care of them. And these are my 3 kids from left to right. It is Margaret, Ben, and Elizabeth. And they're my whole world, but they are doing our estate plan was really a gift to them, making sure that they were well cared for if something should ever happen to my wife and I, that they would be well taken care of and be able to thrive and flourish and make their own way in the world. So here's what we're going to talk about today. We're going to talk about planning for incapacity. And planning for incapacity means planning for something like a coma or dementia, planning for who can make healthcare decisions for you, who can make financial decisions for you. We're also going to talk about planning for when you pass away. And that might mean if you have minor kids, it might mean planning for guardianship. In fact, I'm going to post a demographics question. Just select the option that seems closest or most similar to your situation, if you would, please, just to kind of get a feel for if there are a lot of people with minor children here today, or if more people have grown kids, or what the situation is. Seeing a lot of single without kids that are in attendance here today, and that's great. I will de-emphasize a little bit talking about guardianship. It's something that's important, especially if you know somebody with minor kids. But I will de-emphasize that a little bit and talk more about probate and talk more about estate taxes and some of the other topics. Probate is a court process, and we'll talk about that here in just a minute. But probate, we'll talk about the time that probate takes. It takes a really long time to get through about the cost of probate, and also about the fact that probate is public. And we'll talk about estate taxes. That's a concern that a lot of people have, but the truth is that estate taxes don't apply to most people right now. Most people are able to escape those estate taxes either because the assets that they have are the value of the assets falls underneath the estate tax exemption, or there are some ways to protect those assets and make sure that they don't have an estate tax burden tied to them. We'll also talk about unclaimed property and what that is and how property becomes unclaimed. We'll talk about intangible assets, things like your values and your stories, and how you can pass those along to the people that you love. But before we do, I want to just tell you a little bit more about myself, just so that you know who you're spending this early afternoon with. So again, my name is TJ Scott, and this is my family. My wife's name is Tobin, and my kids, this time from left to right, it's Elizabeth, Margaret, and Ben. And Elizabeth is 6, Margaret is 4, and Ben is 9 years old. And my family is really my whole world. We live in Bloomington, Minnesota. As I said earlier, West Bloomington, Minnesota. And we just recently moved here from St. Paul, from Highland Park in St. Paul. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my son, Ben, was born. And here you can see me commencing on May 12th. And then the very next day, May 13th, which happened to be Mother's Day as well, Sunday, Mother's Day. You can see me holding Ben for one of the very first times. After law school, I found a job with a small estate planning and tax preparation law firm, and I really loved the clients that I was able to work with. But at the same time, I didn't always feel like I was providing those clients with the level of value that they really deserved. And so a little after 3 years, I ended up leaving that law firm. And this is actually a picture from my last day there at the law firm. Someone has to graduate at the bottom of the class. Now, this was something, I'm going to end this poll here. This was something that was not said about me. I always have to say that. I'm a little sensitive to that topic, but this was not said about me. This was said about somebody else, actually by my parents, after they had an extremely negative experience with the estate planning attorney who helped my grandmother plan her estate before she passed away. And in particular, I remember my mom saying this: someone has to graduate at the bottom of the class. And there's a big reason for their reaction to this estate planning attorney and the job that this estate planning attorney had done. The truth is, I don't actually think it was this estate planning attorney's knowledge. I don't think it was an issue of their education or their intelligence. I think what was happening was this estate planning attorney was practicing under a faulty model. And I call it planning for death. And I'm going to talk about that a little bit later. But first, let's talk about estate planning and the different elements of an estate plan that you should have. I'm not seeing anybody saying that they have young kids, so I'm only going to talk about this very briefly. There are 2 types of guardianship that should really be part of any plan for somebody with minor children. There's short-term guardianship, which is the legal documentation that allows somebody to stay with your kids if you don't come home that night for some reason. Before the long-term guardians can be contacted, and the long-term guardians are who those kids are going to end up staying with until they're 18, until those long-term guardians can be contacted and the kids actually delivered so that they're safely with those long-term guardians, they stay with a short-term guardian. And a short-term guardian should really be somebody that lives close by, somebody who lives within 30 minutes. But it's really important to lay out, because otherwise the police don't have a lot of options. The police are really subject to a lot of liability if they try and leave the kids with somebody who shouldn't be staying with the kids. And so oftentimes Child Protective Services gets involved, and it's just not a good situation. I know it's not what I want for my kids. If for whatever reason my wife and I pass away and they need a guardian to watch out for them in the short term. Long-term guardianship is who is going to raise your kids until the age of 18. And if you don't have a plan in place, there is a plan for you that the state writes for you. And that plan is that a judge will decide who the kids are going to stay with. And they do that based on the what they think the best interest of the kids are. But as you can probably imagine, what a judge decides probably, or maybe isn't going to be what you would decide. You know your kids the best, you know where they would thrive and where they would flourish and where they would not be as well placed. And so it's really important if you have minor kids, and I know, again, I don't think many people today here in attendance do, but if you have minor kids, this guardianship nomination process is very important, and it's something that you can get done, again, for a very reasonable fee. And I hope that you will reach out to the people that you know that have minor kids and let them know how important this is and that you know somebody who can help them out. I see somebody asking, can an estate plan accommodate pets upon one's death? And that's a fantastic question. Yes, absolutely. And it can do it in a number of different ways. One of those ways is with something called a pet trust. You can actually form a pet trust and fund a pet trust so that there is money available to take care of those pets and to raise them. In that way, you can also incentivize their new parents or new adoptive parents to take care of those pets and to treat them the way that you would want those pets to be taken care of. So yes, there are ways that an estate plan can accommodate for pets and make sure that those pets are well cared for after you're gone. Great question. So let's talk now about assets and how the people that you love are going to receive the assets. And if you have no plan in place, or if your plan is focused on using a will to transfer your assets to the people that you love, there is a state-written estate plan for you. And that plan is a court process called probate. And what probate is, it's really a lawsuit that you file against yourself with your own money for the benefit of your creditors. And it doesn't sound very good, but that's exactly what it is. It's a one-size-fits-all court process that your estate has to go through if you have no plan in place, or if your estate plan only includes a will. If it's based on transferring assets as dictated in a will, there's this court process called probate that your estate has to go through. And it's just one size fits all. So it's the same process that Prince's estate has to go through, is the same process that your estate would have to go through. And it's just written that way. It's written in a way that it can kind of accommodate both, but it doesn't do it in a terribly efficient way. And it doesn't do it in a way that most people see a great benefit from, or any benefit from, really. And there are a few tack on items that really go to that. So probate is slow. In Minnesota, probate takes a minimum of 6 to 12 months from the date of death. And the truth is that we'd like it to go faster, but it just can't. It's built to be a slow process. There are delays that are actually built into the probate process to make sure that your creditors have time to come forward and make themselves known and get paid, including a 4-month creditor notice period, a 70-day DHS notice period. If you own a house, if you own homestead property, there's just a lot of delays that are built into this process in order to make sure that everything is done in a very methodical and bureaucratic way, really. And everything gets frozen up for that period of time. Usually things aren't frozen for a full 12 months, but things are frozen for at least 4, sometimes even 6 months, something like that, while those creditors are able to get paid, while those creditors are able to come forward and get paid. And again, everything gets frozen up to make sure that there's enough money to pay any creditor who might come forward and make themselves known. And maybe there's a debt out there that somebody will claim that you own, or that you owe a greater debt and than what the assets are. And so the probate court has an interest in making sure that everybody gets paid, and that you wait on any distributions, you wait on making any payments to kids or people that you love until that time period has actually run. Probate's also very expensive. As you can see here, there are all kinds of different fees, and this isn't kind of like a tax or anything like that. We'll talk about estate taxes here in just a minute, but we're talking about different fees that end up diminishing the estate that should be going to the people that you love. Fees like attorney's fees and executor's fees, or personal representative fees, appraiser's fees and bond premiums, filing fees and creditors, payments to creditors. There are just all of these different fees and costs associated with probate. And in Minnesota, we estimate that probate costs somewhere between 3 to 6% of the gross value of the estate. And we use the gross value of the estate because it gives us the best picture of the complexity that getting this estate through probate. A more complex estate, a larger estate, tends to take longer or take more work to get through probate than a smaller estate. So we estimate about 3 to 6% of the gross value of the estate to get through probate. And I see someone asking, does a trust avoid probate? And yes, we will talk about that in just a minute. It's very key that the trust not only be written and executed properly, but also that it be fully funded. And we'll talk about exactly what that means here in a minute. But thank you for jumping ahead and getting to that point that yes, a trust does avoid probate. So with probate costs of somewhere between 3 to 6% of the gross value of your estate, just to put that in perspective, if you have a house that's worth $400,000, and I'll admit that that's a very nice house to some people, although with real estate prices the way that they are, that's becoming more and more real for more people. If you have a house that's worth $400,000 already, probate would be estimated to be somewhere between $12,000, which is 3% of $400,000, and $24,000 to just get that house through the probate process. And we'll actually have a chance here in just a minute to calculate your own probate estate, doing some kind of back of the envelope math to see what it might actually cost for your estate to go through probate. Probate is also public, and I'm showing you here Anna Nicole's will, and this had to be filed in the court, and those court documents had to be made public because that's just the nature of court proceedings. And so in addition to this, in addition to being able to see your will where you talk about your family and you talk about what kind of distributions you want to make, the court also gets to see an inventory of your assets. And again, that inventory of your assets needs to be made public as well as where the distributions are going, exactly who's receiving what. And it seems crazy that all of this information is put out publicly, but there is also a public interest in transparency and being able to see everything. And that's why everything has to be made public. But again, you don't have to make your entire estate public. There are ways to keep things private. And we'll talk about that in a minute. If you don't have a plan in place, then minor children are going to receive assets at 18 and unprotected. And I think all of us know stories about people receiving assets at too young of an age and how it can really affect their ability to handle their own finances in the future, and how it can affect their willingness to go through education and their willingness to hold down a job. And it's just not ideal. And there are ways that you can prevent people from under the age of 18 from receiving. There are estate planning things that you can do. And I will be talking about that more here in just a minute. So here's an opportunity to calculate your probate estate. And here I have kind of an example estate that I have listed. You can see I have a family home, rental property, household goods, automobiles, stocks, bonds, bank accounts, and a business interest as well. And it's really key that these items don't pass by beneficiary designation. They have to go through the probate process, through the court process of probate. So you can see here, I haven't included retirement accounts that often, many of us have retirement accounts. I haven't included life insurance policies that many of us have life insurance policies that paid out. And the reason that I haven't included those is because those don't go through probate. Those go by beneficiary designation. But here, these items are the types of items that go through probate. And so you can get 5%, which falls in that 3 to 6% window. You can get 5% very quickly by moving the comma over one place to make this 85,000 and then dividing that number in half. And so that's how I came up with an estimated probate costs and fees of $42,500. And this might be a little high. This might be, it's an estimate. Again, it's not a tax. It's not a hard and fast number, but it's an idea of what you might expect to pay or what you might expect your estate to pay on different fees like attorney's fees, executors fees, appraiser fees, accounting fees, business valuation fees, bond fees, all kinds of different miscellaneous fees, court filing fees. that go into the probate process. And so now my guess is a lot of you want to avoid probate. Just to add a little bit of a wrinkle here to this accounting, if you have things that should pass by beneficiary designation, but you make those beneficiary designations minors, then there is a similar process to probate that those assets are going to have to go through, called conservatorship. It's really a pain, and unfortunately, that adds to the attorney's costs, that adds to conservator costs, bond costs, all kinds of different costs also go into that calculation. And so here I've added life insurance and retirement accounts payable to a minor, and you can imagine you could get to 1.5 million pretty easily when you have life insurance policies and retirement accounts that you've been growing and building during your working life. And you can see how all of a sudden the cost of probate really balloons very quickly. So again, my guess is a lot of people want to avoid probate. I've already seen somebody posted, does a trust avoid probate? And again, yes, there is a way, a foolproof way to avoid probate, not just using beneficiary designations, but by creating something called a living trust or a revocable trust, and by fully funding that living trust. It's really fantastic. A living trust is an agreement that you write, and you write it with yourself, which is kind of confusing, but that's just how it works. You write an agreement with yourself that you are the person creating the trust, so you're called the grantor or the settlor. You're also the person with control over the trust, which is called the trustee, and you are also the beneficiary, which is the person who can benefit from the trust. And this is a really old creature in the law. It's something that is really well founded and well established. But this relationship between the person creating the trust, the person who writes the rules for the trustee, and the trustee who promises to be bound by those rules and follow those rules are really what make a trust so fantastic and make it such a great opportunity. But again, it's key that you not only write this or have this written for you by an estate planning attorney and have it written for you in a way that you understand, but also that takes advantage of all of the case law and statutory law that's come down through dozens and hundreds of years in our state. It's really important that you have this written for you in a way that takes advantage of those laws. It's also very important that you fully fund it. And what that means is you have to put your assets into the trust to have it work. Now, don't worry, you don't lose those assets. You don't lose access to those assets. You still, because it's a living trust or a revocable trust, you still have complete access and still have complete control over those assets, as well as the ability to benefit from those assets, because we build that in as well. And so you can use funds that are in a bank account that are titled in the name of your trust to go and buy yourself groceries. And there's no problem there. That's something that is absolutely permitted to do, because you can still benefit from those assets that are in your trust. But again, you have to get them into the trust. And so that means different things for different assets. So if you have an investment account, something like a brokerage, then you need to retitle that investment account in the name of the trust. And if you have, and we all have, bank accounts, you need to go down to the bank and sign new signature cards at the bank so that those assets go into the trust. If you have real property, if you own your home, if you own a rental property or a cabin property, you need to execute deeds to transfer that real property into the name of the trust. And if you have stock or bond certificates, you need to follow the process to transfer those stock and bond certificates into the name of the trust. Often it requires reissuing those stock or bond certificates. And there's a process that you can follow, often found on the back of your stock certificate. There's also, if you have personal property, you can assign that into the trust very simply with a document called an assignment of personal property, or a bill of sale is something else that we use here in Minnesota, in order to transfer that property into the trust. And then life insurance and retirement accounts go into the trust after you're gone by beneficiary designation. And oftentimes things like a retirement account will actually kind of flow through the trust or flow through into a separate share of a trust that your beneficiary owns, because they get the best tax treatment there. But that's another provision that you will see in a trust is how does this trust deal with retirement accounts? Life insurance proceeds end up paying out into a bank account that is already held in the name of the trust. So it's a very simple process to get those life insurance proceeds into the trust, so long as the beneficiary designation does say that it needs to go to the trust. And there's a specific way to write that as well. Okay, so that was a lot. Trusts are really fantastic, and they're something that I love to talk about. If anybody has any additional questions about trusts, or if anything wasn't completely clear, again, using a trust, you can avoid probate. And there's really a foolproof way to do that. I see somebody saying, does beneficiary need to be a family member? Absolutely not. You can make the beneficiary whoever you wish on your trust. And again, it will start with you during your lifetime. And even if you become incapacitated, you'll still be the beneficiary of your trust. But if something happens to you, or when something happens to you and you pass away, you can name another beneficiary who does not have to be a family member. It doesn't have to be somebody that you're related to. It can really be anybody. And you can get that treatment where it transfers to that person really in a great way. Okay. Now, let's talk about estate taxes. And I really enjoy talking about estate taxes because it's an opportunity for me to give everybody some good news, or almost everybody some good news. There are estate taxes levied on the federal level and on the state level here in Minnesota. And on the federal level, the estate tax amount goes up to 40 cents on the dollar. It's really punishing for large estates. But it's only punishing for those large estates because there is an exemption on the federal level of $11.7 million. And what that exemption means is for your first $11,700,000, you pay nothing in estate tax to the federal government. And so again, that's great news to most of us because we don't have $11.7 million where the federal government is going to get involved and start taking money in the form of an estate tax. That number is also, you're able to double that if you are married. And there's something called portability where it actually transfers to the surviving spouse. So you're able to get a $23.4 million exemption to pass your assets without federal estate tax due on them if you're married. In Minnesota, though, we also have an estate tax that's levied on us by the state of Minnesota. And that estate tax starts at 13 cents on the dollar and goes up to 16 cents on the dollar. But like the federal tax, we have an exemption in Minnesota. And again, good news to most of us is that exemption is $3 million. That exemption is pretty high, where most of us won't end up owing to the state of Minnesota any estate tax. That number is doubleable if you're married in Minnesota. But in order to double that $3 million tax exemption, you do have to do some planning and lay out some things so that it's clear after the first person passes away. Some of those assets are given estate tax treatment to make them not vulnerable to estate tax treatment on the survivor. It's confusing. It's a lot to go through. Here's what you need to know. If you have assets in excess of $3 million, you really need to reach out to an estate planning attorney unless you feel comfortable paying 13 cents on a dollar up to 16 cents on a dollar towards Minnesota estate taxes after you're gone. That's the high and low of it. Okay. And the same thing, if you have assets over $11.7 million and you don't want to pay up to 40 cents on the dollar, you don't want your estate to pay up to 40 cents on the dollar, then you really need to reach out to an attorney who can help you out and make sure that you're getting the best tax treatment for your estate after you're gone. Good news. That's my good news slide. Okay. And it is good news, again, to almost all of us. Will your assets be lost to the state? So right now in the State Department of Unclaimed Property here in Minnesota, we have $700 million that is being held by the Minnesota Department of Unclaimed Property. And across the nation, it's something like $58 billion that is sitting in state departments of unclaimed property. And the way that money gets there is oftentimes somebody will die or become incapacitated, and their family just doesn't know where all of their assets are. And so there's a bank account that they opened, or there's an investment account somewhere that they opened, or there are stocks and bonds somewhere that they hold that just aren't accounted for when the family is trying to collect all of their assets and get everything handled. And when that happens and those assets are unaccounted for and they go for a certain period without any activity on them, they end up in the State Department of Unclaimed Property. And this is especially prevalent right now, where a lot of us have electronic statements turned on for our bank accounts and for our other accounts. And so you can imagine that your family can't even go through your mail to find where all of your accounts are anymore, especially if those accounts are only sent quarterly or annually, something like that. So this is something that a lot of estate planning attorneys don't focus on, but I think is something that is vital to an effective estate plan, or to an estate plan that's really going to work, is making sure that all of your assets go to the people that you want to receive them. And this is something that is a really big deal for myself, because I have 3 young kids who are going to need those assets if anything happens to me. And those assets aren't endless. It's not like they're going to be getting endless assets. And because they're not going to be getting endless assets or more assets than my kids can use, I want them to receive every asset that they can to be used for their care and for their growth into becoming the people that I hope they can one day be. This is really cool. You can make your living trust a real treasure chest. And when I say that, I mean you can build in asset protection for your heirs over their inheritance, so that their inheritance is protected from things like divorce and like lawsuits. Again, this is something that is really cool. And if it sounds interesting to you, if you want to know how your heirs' inheritance can be protected from things like a divorcing spouse taking half of that inheritance from them, I hope that you will reach out to me and we can talk more about it, because it's really cool. It's a really great opportunity to give a fantastic gift to the people that you are already giving a gift of your inheritance to, but make sure that they're able to use the inheritance for what you hope that they're going to be able to use it for. So planning for incapacity is something that is extremely important. And without having a plan for incapacity, you can end up having a lot of conflict in the family and end up having a lot of time in court in the family. And so here on the screen, I have pictured Terry Schiavo, and Terry had a case where through a heart problem, she ended up in a vegetative state back in the mid 2000s. And in Terry, this was a really bad situation. It ended up that her husband thought that Terry would no longer want to live in this vegetative state, would no longer want to be kept alive in this vegetative state. But her parents believed that Terry would want to stay alive in this vegetative state if there was any chance of her interacting or being at all present to the outside world, or if there was any chance that a miracle could bring her through and restore her to a greater level of functioning. Her parents believed that that's what Terry would want, is to be kept alive. And so there was a huge fight between Terry's parents and Terry's husband. And there were court cases all throughout the United States, or all throughout the press in the United States. It was actually happening down in Florida. But we were all tuned into this back in the mid 2000s, and it turned out that eventually the husband won. I think he had to take it all the way up to the Supreme Court, and they ended up turning off the life support, and Terry did pass away. But this expensive and frustrating, conflict-ridden court battle didn't have to happen. Terry could have, and I know this is, I don't mean to sound harsh on her at all. but this is something that you can lay out. You can lay out what your wishes for your healthcare are, and you can make sure that that court and conflict that Terry's family had to go through isn't something that your family has to go through. I see another question coming in. Can the estate plan designate a nursing home with or without private pay? And then something money is gone. That is a really fantastic question. Yes, you can create instructions to your guardian or to your healthcare agent about where you would want to be and where you would want to stay, what kind of nursing home you would want to be in. That is a really good question. I know a lot of people have concerns about long-term care and about the expenses right now of long-term care, and it is very high. Nursing home care can cost over $10,000 a month, not a day, thank goodness, but a month. You can imagine if you're paying expenses of over $10,000 a month, that your savings, your assets can go very quickly. So there are ways to plan for that. There are ways to secure your assets to make sure that you're able to give an inheritance, you're able to give something to the people that you love, that you want to receive, and at the same time that you're able to reserve enough money to pay for nursing home care if there is a private pay period, as well as have the government kick in and be able to help with the expenses of nursing home care at some point when the money is no longer available. So there are ways to do that, but again, it takes affirmative planning, and the earlier that you get to that planning, the earlier you start to take care of it, the better. If you're 20 years old or 30 years old and you have a concern about this because you have somebody in your family who showed signs of dementia or is showing signs of dementia, and now is a great time for you to look into long-term care insurance policies. The same is true even if you're 40 or 50 years old, maybe even 60 years old, that there are some good long-term care insurance policies that you can look into. It can be really difficult to make those long-term care insurances pay. And so it's really important that you get a good one and you get one that is financially stable. But that is a very good way to affirmatively pay if you're younger. But even if you're not younger, there are ways that you can take care of your assets and that you can make sure that you are able to stay in a nursing home and in a level of comfort that is right for you, or that you need in order to continue on. And that's something that we can talk about more one-on-one if anybody has that concern or anybody is interested in learning more about that. Great question. So if you'll give me just a second. So what can you do today to do the right thing for your family, and what should it cost to plan right? We've gone through kind of a list of horrible things, right? Or parade of horribles, or whatever you want to call it. And we've talked about probate and the time and cost of probate. We've talked about the fact that probate is public and exposes everything to the public for scrutiny. And we've talked about planning for incapacity and not having a plan for incapacity, and how that can lead to a lot of court and conflict for your family, really at a time when they need to be coming together in order to make sure that things are taken care of and in your life, and that they are well cared for in the way that you want them to be. And we've talked about estate taxes again, that it doesn't apply to most people, but if it does apply to you, that it's something that you really want to make sure that you get in front of and that you're able to plan for and take care of. We've talked about the Minnesota Department of Unclaimed Property, or the Department of Unclaimed Property in the state where you are. I know that we had somebody joining us from Texas earlier as well. And so there is, whatever the State Department of Unclaimed Property is, there's a process for making sure that you inventory your assets and that nothing gets missed or nothing gets lost when you want things to go to the people that you love. And so your options to create a plan are really twofold. You can either try to do it yourself, or you can work with a lawyer. And do keep in mind, not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer? And there are some times, again, keeping in mind, I know that I'm kind of biased as an estate planning attorney, but I want to help you through. I want to help you make this decision or give you some guidance in when it's most beneficial to work with an attorney, because obviously there's an expense to working with an attorney. And we'll talk about that in just a minute. But would you benefit from working with a lawyer? And if you own more than just your personal belongings, things like cars, clothing, jewelry, furnishings, if all that you own is your car, clothing, jewelry, then you might be okay to do it on your own, to do your own plan yourself, do something like an online will. And I say that because if that's all that you own, there is a process where you can actually, the people that you love can actually avoid probate, so long as you don't own real estate and the assets that you own total less than $75,000. There's a simpler process that they can follow in order to get your assets through the process and get them into their name. And so that is something that is possible if your assets are that low. However, if you own a home, if you own assets in excess of $75,000, then generally it's a good idea to work with an attorney and to make sure that you are consulting with an attorney so that the plan, as you lay it out, what you want to have happen is really what's going to happen. If you want to ensure that the people that you love stay out of court and out of conflict and have someone to turn to when something happens to you, then you've got to work with an attorney. You have to have somebody that they can turn to, somebody who knows your wishes and knows what your desires were, and can communicate that even beyond what your legal documents are able to communicate. If you want a kids protection plan, which includes the short-term guardianship as well as the long-term guardianship, and other documents like medical powers of attorney and instructions to caregivers, instructions to guardians, as well as a whole lot of counseling or consulting information that surrounds that kind of planning for minors, then you have to work with an attorney. And if you want to avoid probate or estate taxes, or you want to protect your children's inheritance or your loved one's inheritance in something like an asset protection trust, then again, you have to work with an attorney. Those are things that only an attorney can do. And if you want to guarantee that your plan is going to work when your family needs it to work, then you have to work with a lawyer. And this really came up for me. It was a little over a year ago. I was preparing to bring my son out to go fishing. And there's a little lake by us that we were going to go fishing at. And I had just gotten a new rod and reel. And so I was putting fishing line on this new rod and reel. It had shipped to me without any fishing line on it. And I don't know what I did exactly. I thought that I had it going the right way, and I thought I was doing everything just the right way. But as soon as I thought that I was done, as soon as I went to pack it all up and to bring it with me to go out fishing, that fishing line just started jumping off of the reel and was everywhere. And it was a tangled mess. And it was really unfortunate. It was frustrating that I had caused this mistake in trying to do it myself and trying to put this fishing line on myself. But you know what? It wasn't that big of a deal. I took and I snipped that fishing line, and I threw away probably 30 cents worth of tangled fishing line. I was able to get everything working the right way, and I was able to put a hook on, and my son and I were still able to go fishing that day. Not a big deal. That was a very good example of a do-it-yourself project that has very low stakes for failure. And also, I was aware immediately that I had failed or that I had screwed up the way that I had put on the fishing line. And so that was a great do-it-yourself project. Estate planning is not that way. Estate planning is high risk. If something happens and there's a mistake made in one of your estate planning documents, that can have huge impact on your family or on the people that you love. And you're not going to know right away whether your estate plan is going to work the way that you envision it working. The only way that you can know that your estate plan is going to work is if you work with an estate planning attorney who has been doing this for enough time. They've seen it work, and they've seen how you need to have things in order to be sure that it's going to work the way that you want it to work. And so you're left with this uncertainty, and that's not something that you should have after you've created an estate plan. Creating an estate plan should be lifting a burden off of your shoulders, that you should know now exactly what's going to happen for the people that you love. And that's how it should feel, not give you uncertainty. Here's just another added point. If you want to give your assets to someone other than your kids, then you should really work with an estate planning attorney, because there are some finer points in giving your assets to somebody who wouldn't ordinarily be the person to receive those assets. So you would really benefit from working with an attorney if that was the case. Now, you know by now whether you would benefit from working with an attorney or not, but what attorney should you choose? Who should you work with to get your estate plan done? And I brought up this quote earlier. Someone asked to graduate at the bottom of the class that this was a reference to my parents' experience with my grandmother's estate planning attorney. And again, I don't think this estate planning attorney was dense or unintelligent. Maybe they were, but really, I think they were just practicing under a faulty model. And again, I call that model planning for death, because the typical estate planning experience right now is that you get form documents where somebody is going to fill in your name in a form document, and that may be all that they change. They fill in your name and some information at the end about how distributions go out, and that's all that they change. And it's very set it and forget it. That they fill in this information, and you're going to take it. You probably won't understand it well because the attorney won't have explained it. They won't have educated you and empowered you in making the decisions that you wanted in those documents. So you'll just take it and you'll put it in a bottom drawer and forget that you even did it, or maybe you'll vaguely remember that you did it, but it's not treated as the living document, as the document that may require changes in the future should be treated. Typical experience isn't going to keep your money out of the Minnesota Department of Unclaimed Property or the State Department of Unclaimed Property where you are. That's just not something that generally falls under an estate planning attorney's wheelhouse, or it's not something that they are thinking about. But again, I think that's so crucial. If things are ending up in the Department of Unclaimed Property, that's a failed plan in my mind. That's a plan that did not take care to shepherd or to steward all of the assets to the people that you wanted to receive them. Typical experience might avoid probate, but it might not. In fact, a lot of estate planning attorneys plan to put an estate into probate, and there are very few good reasons to want to go into probate if you have a lot of creditors, or if you think that you can avoid certain debts from creditors by going into probate, but that's almost never the case. But a lot of estate planning attorneys will plan with a will-based plan because they know that down the road, that probate work is going to come back to the law firm, and somebody is going to end up, hopefully, that attorney thinks, hopefully that attorney will end up doing the probate down the road, so that they're paid on both ends. They're paid as an estate planning attorney, and they're paid as a probate attorney. But again, I don't think that that's an effective way. I don't think that's what my clients want. My clients come to me because they want things simple. The simplest way to handle things is not to go through the probate process. A typical experience probably isn't going to keep the family out of court and out of conflict. It's only going to focus on the money. It's not going to focus on intangible things like your stories and your values, which I capture in a process called a family wealth legacy interview. It's only a typical experience is going to leave assets to heirs unprotected without that asset protection, meaning it might be accessible to a spouse in a divorce, where a spouse would end up with half of your loved one's inheritance, which is not what most of us want. Typical experience, you're not going to have ongoing legal guidance from the attorney, because that attorney is going to be charging you hourly fees, probably while they're putting the estate plan together and afterwards as well. And you're not going to want to reach out to that attorney when you know that you're going to be getting a bill in the mail down the road. And a typical experience is not going to adequately protect kids. Especially not going to include that immediate term or that short-term guardianship nomination that is so crucial. And really, you're going to be left with this question: is this going to work when I need it to work? And that's not a question that you should have after you've done estate planning. On the other hand, I plan in a totally different way. I call it planning for life. And it really is a different experience, because you get to choose your fee from a range of flat fees that I lay out for you. And I'll talk about exactly what those fees are here in just a minute. But planning with me is going to keep your money out of the hands of the state. We create an inventory together to make sure that all of your assets get to the people that you want to receive those assets. Planning with me means protecting your kids totally in the immediate and in the long term. It means keeping your family out of court and conflict. And I think that's so important. Really, at heart, I'm a peacemaker. And I know that estate planning, the end of somebody's life, can really lead to a lot of court and conflict in the family. And I've seen it tear families apart before. And it breaks my heart. It's not something that I want to see. I'm a peacemaker, and I want to help you to keep your family intact and to avoid undue conflict that could tear at your family. Planning with me means you're going to know that you've made the right decisions, because again, I am really enthusiastic and really emphatic about educating and empowering my clients. I think that that is part of the process. You should be making the decisions, and you should have all of the information, all of the knowledge to make the decisions that you want to make. I'll be here to guide you. I'll be here to help you and counsel you to make the right decisions, but it's your decisions, it's your plan. You really need to be able to understand it and make those decisions. Planning with me means that you can protect the family money from outsiders, again, from things like divorce and lawsuits. And you're going to have a lifetime of guidance and protection, because I'm not going to be charging you hourly fees down the road. If there are big changes that need to happen to your plans, there might be a fee for that. There will probably be a fee if we need to change your documents to say something different than what they say at our first meeting. But I'm not going to charge you for picking up the phone and calling me and saying, hey, TJ, we're buying a new house. Can you remind me of the name of my trust so that I can take ownership in this new house in the name of my trust? There's not going to be a charge for that. I don't think that that is a good model, charging people for picking up the phone or sending me an email. I want us to stay in communication, and I want to be accessible to you. So I'm really passionate about that. I'm really passionate about giving you that lifetime of guidance and protection. And planning for life, again, planning with me, it means that you know that your plan is going to work for you when your family needs it to work. And again, this is just a gift that you're giving to the people that you love the most. You're making things easy for them, simple for them. You're taking care of it here. So what should it cost to do an estate plan? And let me provide a little bit of context. Again, this planning is going to save your family at least $12,000 if all that you have is a house worth $400,000. And that's based on the estimated costs of probate. 3% of $400,000 again is $12,000, an estimated $12,000 in probate. But again, you can avoid probate if you work with me and do an estate plan with me. If you have assets over $3 million, this planning is going to save your family at least 13 cents, up to 16 cents on the dollar for every dollar in excess of $3 million. And again, those are the estate taxes that we can plan around, that we can take care of. You can expect to spend $1,500 minimum for a typical estate plan from a typical estate planning attorney, who's probably going to charge you hourly. They're probably going to give you an estimate of what it might cost, but it's going to be inexact, and you're not actually going to know what it's going to cost until you get to the end and they have added up all their time and they've sent you out a bill. It's going to cost $1,500. And it probably isn't going to keep your family out of court or conflict. It's not going to ensure your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money. It's not going to cover your kids' immediate care or your values or insights, stories, or experience. You know, those most valuable intangible assets that are most often lost. And again, that's a minimum for what you can expect to pay for a typical estate planning attorney. Or you can plan with me. I'm a personal family lawyer, and I am in a group of personal family lawyers who are really passionate about educating and empowering our clients and giving them the results that they want from putting an estate plan together. And I think that is really the key. I want to give you the value of your estate plan, the value that you should expect from your estate plan. And that means not losing assets to the Department of Unclaimed Property. That means not having your family have to go through probate. That means not having your family to have to go through things like guardianship or conservatorship. You should be able to expect that your plan is going to work for you when you need it to work. And planning with me costs somewhere between $2,000 and $8,000. Again, you'll be able to pick that fee, that flat fee, based on your needs and your budget and the needs of your family. And I'll again provide some guidance, but it is your choice what you want from your plan, and you're going to know that your plan is going to work when your family needs it to work. And so I really want to make this easy for everybody. And I want to make this easy by offering you an absolutely free initial meeting with me. And that's the family wealth planning session. And it really has a value of $750 because it's a 2-hour long session with me where we're going to talk about everything. We're going to talk about your family and your family dynamics. And we're going to talk about the things that you own and exactly how you want to get those things that you own to the people that you love. And so I just posted in the chat my link to actually book with me. You'll be able to see my calendar online, click into that link, and then click into Family Wealth Planning Session. And that's that 2-hour long session with me. I do have a little bit of homework that I want you to do, a little bit of pre-work before we get together in order to make our meeting as effective as possible and really put you into a position where you are able to best understand the plan that you're writing, and really are most empowered to make decisions about the assets that you have, because you're fully aware, or you've collected all of the assets and you have them gathered in front of you, not literally, but in your mind, and you have also thought about and given care and thought to who's in your family and who might play a role in your estate plan. But in addition to that, I don't want to just give you that free meeting, even though that free meeting is valuable, and I make it valuable for my clients to make sure that they are able to get something really special out of it. I take all of this information and more that we've talked about today, and I make it specific to you and to your situation. And that's why it's so valuable that you get those 2 hours with me. So I also want to give you $250 towards the estate planning package of your choice if you will reserve your appointment by the end of the week. And when I say the end of the week, I mean the end of the day, Saturday. So I'm going to send you an email today. I'm going to send you an email on Saturday letting you know that this is the end of the week. And if you book that meeting, and let me just say, some of you have probably clicked through and looked at my calendar and you've seen that there are no times left to meet with me in November. I do have some times still left in December, although they're starting to get kind of picked over at this point. But all I want you to do is schedule a time to meet with me by the end of the week. It doesn't have to be that we're actually meeting by the end of the week. It's not possible. There's just not time to do that on my schedule. But I just want you to get the meeting in December or January or February booked so that you have it scheduled and that you are taking the next step forward to getting an estate plan done for your family. And really, estate planning is about momentum. It's about keeping your momentum going forward. And the next step to take is clicking on that link, looking at my calendar, finding a time with your partner, or finding a time that you know is going to work for your partner on my calendar, where we can all meet together and talk about your assets and talk about your family and really get clear on everything and start writing a plan if that's what you want to do. Because again, I don't know if I said this before, but that family wealth planning session is a no obligation session with me. I just want to meet with you, and I just want to lay out with you exactly what you can expect from your estate plan, the way that it's written now, whether you have a will in place, a do-it-yourself or online will, or whether you don't have anything in place right now. Even if you have a trust in place right now, I can review that trust and let you know if it's going to do what you want it to do. And let me tell you, if your estate plan, as it's written now, does exactly what you want it to do, or if the pains, for lack of a better word, that your family is going to have to go through after you're gone in dealing with things aren't worth the amount of an estate plan, of putting together an estate plan with me, then you can leave the family wealth planning session with that knowledge, and with the knowledge that everything is set up at least in an okay way, or in a way that I'm okay with what my family is going to go through after I'm gone. And that's just fine with me. Again, I'm very passionate about educating and empowering people in my community and in this area in general. And that's what I want to do. And that's why I'm offering you this free meeting, because I really believe strongly in educating people about this and giving them the knowledge to make the decisions for themselves. And again, if you're booking that meeting, I hope that you're booking it right now, because if you book it right now, then you don't have to worry about me following up in those emails and finding those emails. And clicking through and finding the right links and everything in order to get on my schedule. It's not going to be difficult, but I hope that you're doing it now so that you can get that $250 towards the plan of your choice after we meet in that family wealth planning session and you decide that you want to continue and that you want to go on and build a plan. And really, the reason that I give you that $250 is to incentivize you to keep the momentum going. I am going to stay in touch with you. I have a newsletter that I send out, and I try and send it out once a month with some really valuable tips and insights about estate planning and some information about what's happening with me and with my law firm. And I don't mind sending that out, but it can be really difficult trying to re-motivate yourself or to restart this process if you give it up now. It's all about momentum. And right now, the best thing that you can do to keep your momentum and to keep the momentum in getting an estate plan written that is going to take care of the people that you love is to get on my calendar and make sure that you have a specific appointment set where you know that you're going to be taking the next steps towards getting an estate plan in place for you, the people that you love, or just finding out that the estate plan that I have is exactly what I want or is okay with me for the people that I love. If anybody has any questions that they want to send through, I will be taking a look here. Let me just tell you some questions that I often get. One of the questions that I often get is, what does a family wealth planning session look like? And again, it's a 2-hour-long session. It's broken into 2 parts. The first part is really education about estate planning, and it's really talking about things specific to your situation. So it's generally totally virtual, but that first half is going to be talking about things like who in your sphere, who in your circle would be the most likely person to step up and collect everything for you. And what would happen if you became incapacitated? Who would be the person to step in and want to make healthcare decisions for you? Is that the person that you would want making healthcare decisions for you? Who would be the person to make financial decisions for you? And is that the person that you would want making financial decisions for you? Or is there somebody else that you would want making those decisions? And we'll talk about what probate would look like for you. We'll talk about, based on your assets, what assets would have to go through probate. Here's something that you might not know. If you own assets in another state, if you own something like a cabin in another state or a rental property in another state, you actually have to open a probate, not just in the state where you're domiciled, but you also have to open up something called an ancillary probate, where you hire an attorney in that other state in order to take that asset through probate. And that's something that a lot of people don't know, but that's something that it's an example of something that we can get specific on when you've completed the homework and when we have all of the information about your assets right there in front of us, that I can tell you more about what probate is going to look like for you and exactly what that situation is. We can talk about whether you're going to owe estate taxes and some methods that you can use in order to minimize the amount of estate tax that your estate is going to have to pay. And we'll talk about how you want the people that you love to receive the assets that you have and exactly who those people are and what you want it to look like. And we're going to talk about all those things in the first hour of our meeting together. And we might get into additional areas. We might start talking about nursing home care. We might start talking about the expenses of nursing home care and whether that's something that you want to pay out of your own pocket, out of your funds or your assets that you've spent your life growing, or if you want to see if there's another source that can pay for those nursing home care costs. Another source like the government possibly, or like a long-term care insurance policy that can make payments towards that nursing home care cost. We can talk about things like I've had questions before about manufactured homes. and whether a manufactured home is personal property or whether it's real estate. And what treatment does it receive then when it goes through probate, or does it need to go through probate if it's a manufactured home that isn't attached to the ground? We'll talk about things like if you have grown kids, whether or not they have powers of attorney and healthcare directives in place. And if they are in college, how important it is that they have a power of attorney and a healthcare directive so that you can access their healthcare information. You might not realize, but you might actually be foreclosed from receiving information about their healthcare. Even if you're paying for their college and you're paying for where they're staying, you're paying for all of that. If they ended up in the hospital, you may not have access to their healthcare information about what the situation is and about what their state is without them being cognizant and having capacity to grant you access to that healthcare information. And that's a scary thought for a lot of parents that could be the case. But unfortunately, that's true in the society in the way that our society deals with things. We'll talk about things like special needs trust or supplemental needs trust. And we'll talk about if somebody in your family, maybe it's a child or a grandchild, is receiving government benefits right now, how can you ensure that that person will still be able to receive that government benefit for food or for clothing or for healthcare or for housing, whatever it might be? How can you ensure that that person can still receive the government benefit, but can also have a share in the inheritance that you want them to have? And that's often done with something like a special needs trust or a supplemental needs trust. It's so important because if you don't have something like that in place and all of a sudden they receive a big inheritance, a big dump of money on them, it can knock them off of that government program. And although they have some money to pay for the things that they need, things like housing for the short term, that money is going to run out. And when it does, they're going to have to requalify for the program that they were on in order to start receiving those government benefits again. And that can take time. It can be a painful experience to go through that procedure to requalify for that government benefit. We'll talk about things like who can oversee my money? Who out there, I know that I had the question earlier. I don't have any family that can help me out and that can make these, that can take on these roles for me. So we can talk about who is it that's going to oversee my money and going to oversee my finances if I don't have somebody like that in place. We can talk about exactly how we can get somebody into that role to take that on and what you can expect to pay for them to serve in that role. But that's all in the first half of the family wealth planning session. And the second half of the family wealth planning session then is an actual design of your estate plan. So we'll talk through all of these things and you'll tell me what your concerns are. And then together, we'll address those concerns by designing an estate plan to take care of those things. And we will put together exactly an estate plan that can help you avoid probate, that can make sure that somebody is in place to make decisions for you, healthcare decisions, financial decisions. We'll talk about making sure that we have a plan in place so that you can avoid estate taxes, at least to the maximum amount that you can. And we'll talk about making sure that your heirs or the people that you love are receiving the inheritance that you want them to receive in the way that you want them to receive it. And we'll go through all of that in the second part of the meeting if you want to continue and again, do that design. If you don't want to do that design, if that's not something that you're interested in, that's okay. Our meeting would just end at the hour mark after you've gotten this new information. And again, I would just be really happy that I was able to give you that information and talk you through that and make sure that you had that information. So I'm looking over here. I'm not seeing any new questions coming in, and that's okay. Maybe we just don't have any questions. I am seeing that a number of people have signed up for family wealth planning sessions, and I'm really pleased to see that. I'm really excited to meet with you. I'm excited to get to know more about your situation and where things are at for you. And I'm excited to help you start to untangle some of these subjects and some of these topics and really get it figured out for yourself and for the people that you love. It has been a pleasure to be with you here this early afternoon. Please look in your email later today. It could be quite a bit later. I'll try and get to it right now. But I am going to be sending everybody a recording of this webinar if you want to watch it again, or if there's some part of it that you want to watch again. I'm going to send you a recording of this webinar on YouTube. Please look in your email for a link where you can book with me if you haven't already booked with me. And again, that email should be coming out here in just a little bit. You may have to look in your spam filter. It's embarrassing, but it does sometimes happen that that my emails end up there. I hope that it won't happen. I hope that you'll be able to find my email, and that that you'll be able to book an appointment with me if you haven't already. If you've clicked into that link, you can also just keep that window open, and you should be able to make an appointment from there. Again, I just want to thank everybody for being here with me today. I really enjoyed meeting with all of you. I had some fantastic questions come through and some fantastic comments about your situation and things that you know or things that you've experienced. I love having that kind of feedback and having that kind of information come through. So again, I just really want to thank everybody for being on the call today. And I want to wish you a very, very enjoyable rest of your day. So take care, everyone.